Excuse me.
Okay, I'd like to call to order this February 13th, 2023 meeting of the Town of Kiowa Island Board of Zoning Appeals. I'm Frank Cassidy. I'm the chair of the board. The board members who will hear your case today are Morris Hannon, Ben Farabee, Lynn O'Leary, Jay Lewis, and myself, Frank Cassidy. Staff members here are John Taylor Jr., our planning director, and Joe Wilson, the attorney for the BZA. Our case rulings from this and any BZA meeting are available for public review and inspection during normal business hours here at the town hall. Since our meeting is being conducted via Zoom, I'd ask everybody to please be reminded not to speak over one another so that we can have a clear and clean record. And I'll try to keep that organized by calling on people as they raise their hands. I'd like to ask if those who are here today, if you're familiar with the procedural workings of the BZA. If you are, I'll skip over the comprehensive explanation of the BZA's workings. Okay, if I skip that? All right. Because today's hearing is a public fact-finding meeting, we are in compliance with the Freedom of Information Act and SC Code 6-29-70. Because this is a quasi-judicial body, everything said in this meeting must be complete, true, and accurate. All of the information provided to the BZA is considered evidence, and this board may certify contempt of circuit court if false statements are made, either in writing or orally. Staff has placed a sign-up sheet for anybody who wishes to address the board out in the hallway, and we'll hear from folks as we move along. Each person who wishes to address the board today will be sworn in order to expedite this procedure. I'd ask you, if you're going to speak today, if you'd please stand, and Mr. Wilson will administer the oath of office.
Could you raise your right hand, please? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do. Thanks.
Thank you, everybody. I'll now call case BZA 22-000013 at 222 Seamarsh Drive. Staff will provide facts pertinent to the case. I'll then ask the applicant to address the case. The applicant will please stand at the podium, give your name and current address for the record before presenting testimony. I'll then ask those speaking either in support or in opposition to the case to speak, and you'll have 3 minutes to make your comments. The applicant will then have the opportunity for rebuttal. John, you're up.
Yes. Today's case, BZA 22-000013. Today we have a variance request for the reduction of the required 30-foot rear setback. And this is for approximately 786 square feet of encroachment and for a proposed single-family residence. Subject property is 222 Seamarsh Drive, and the TMS number is 207-03-00054. Subject property is zone R1 residential and is just under 12,000 square feet in size. Setbacks for the particular property are outlined as follows. The front is a 25, the sides are 15, and the rear is 30. That's the rear along the OCRM critical line. Here is a zoning map of the current subject property. Subject property is zone R1. Properties to the east and west are also zone R1. The property is adjacent to critical area at the rear or to the north. This property is subject to review by the Kiowa Island Architectural Review Board. Here are a few aerials of the image of the site. You can see the current property outlined here. The current property is vacant. Proposed plans for this single-family residence include a pool with a proposed lot coverage of 39.43%. The maximum lot coverage for this particular lot is 40%. The applicant did submit to the Architectural Review Board, and the Architectural Review Board did grant approval, stating the approves of the proposed rear setback encroachment of pool and decking in the first floor single-story heated space as proposed, giving the significant critical line movement and resulting in lot size. Here are a few images of the current site. This is looking from the street view. The image to the left is sort of to the left of facing the property. More images of the property being staked out. Adjacent properties both to the east and west. And images of the property at the rear. I also want to note that prior to this application being received in last year of 2022, the applicant or the property owners did amend the property line boundaries for this particular lot, and you can see that as referenced in your materials based on application subdivision 22-000009, and that plat was recorded on August 4th of 2022 in booking page S22-0166. Here is the proposed plans as outlined, which includes a single-family residential structure. The encroachment as referenced as part of your materials to the rear. The area is sort of highlighted in blue. Staff did conduct a site visit, and the following determinations were made pertaining to the approval criteria that's outlined. And so regarding the approval criteria of A, there may be extraordinary and exceptional conditions pertaining to the property. And this is due to the required setbacks. That includes the rear setback along the OCRM critical line. The applicant has stated in their letter of intent, importantly, the critical line has changed over time, and as of today, it's situated further into the subject property than it did previously. And if the setbacks from the critical line remains in place without the variance, a home that is similar in placement on the subject lot would not be possible to construct. And as a significant reduction in the depth of the building envelope would be required. The critical line setback also reduces the driveway access and limits parking. And this is an extraordinary and exceptional circumstance because the adjacent lots all have homes on it already constructed on them. And the property is only undeveloped lot in the area. So it is the only property that is subject to harsh results of the setback requirement by the adjusted critical line. The second criteria B, these conditions may be unique to the subject property and may not generally apply to other properties in the vicinity. The subject property is adjacent to critical area at the rear, similarly to adjacent properties. And the subject property is zone R1 residential, so our property is adjacent to the subject property. The subject property is currently vacant, whereas residence exists to the east and west of the subject property, and existing structures in the vicinity may or may not have similar encroachments based on the current setback standards. The applicant has stated in their letter of intent that as stated above, the other properties in the vicinity for which this setback requirement apply all have homes that were built on them previous to the change in the critical line. And this makes the enforcement of this restriction inapplicable to the adjacent properties. Because the homes exist on the properties in the vicinity, this restriction would only apply to the subject property, and for the simple reason that the owner did not build on the property at the same time as the adjacent owner started their construction. Criteria C, the application of this ordinance to this subject property. This would prohibit the construction of the proposed single-family residence as it encroaches into the required rear setback of 30 feet. However, it does not unreasonably restrict the utilization of the property. And the applicant has stated in their letter of intent that if the setback requirement remains at 30 feet opposed to the requested variance of 15 feet, then the construction of the home would be unreasonably restricted. The home would need to be smaller in construction and would sit further away from the marsh than adjacent properties, causing an aesthetic abnormality with the location of the home on the subject property versus the neighboring properties. This would also limit the expanse of the home's view of the marsh and river, since homes on each side of it would block views on each side, which would impact the subject properties unreasonably. Criteria D, the authorization of this variance may not be of substantial detriment to the adjacent properties or the public good. The proposed structure does sit approximately 15 from the rear critical line, and the encroachment into the rear setback is approximately 15 feet. The applicant has stated in their letter of intent that this will not cause any detriment to the adjacent properties or the public good. The granting of the variance would merely allow the home on the subject property to be constructed in a similar lot position to the adjacent properties. The character of the zoning district would not be harmed in any way whatsoever. The variance allows for the construction that matches the aesthetic of the zoning district rather than take away from it. The criteria E that's been outlined, granting of the variance would not allow the establishment of a use not otherwise permitted. This is an allowed use in this particular zoning district, and the applicant has stated in their materials that the requested variance does not violate the requirements of the Board of Zoning Appeals. Criteria F, the BZA may not consider profitability when considering this request, and the applicant has shared in their materials the requested variance does not request of any consideration based on profitability, and rather it requests a variance to allow for a use that is similar to the adjacent properties that does not harm the character of the zoning district while preserving the existing land value. Criteria G, the need for the variance may be a result of the applicant's own actions. The current site is vacant, and per the applicant's letter of intent, the alteration of the critical line, and therefore the location of the setback on the subject property is not the result of the applicant's actions. Criteria H, granting of the variance may be contrary to the public or neighborhood interests, may not adversely affect other property in the vicinity, nor interfere with the harmony, spirit, intent of these regulations. And as stated, the Architectural Review Board did grant approval. This was done on March 22nd of 2022. And they stated the ARB approves the proposed rear setback encroachment of the pool and deck and the first floor single-story heated space as proposed, given the significant critical line movement and resulting lot size. The applicant has stated in their letter of intent the granting of the variance will allow for the site location of the home on the subject property to be similar to the other properties in the vicinity, whereas enforcing the ordinance without allowance for variance will cause the subject property to lack harmony with the nearby properties. Granting of the variance would not be contrary to the public or neighborhood interests, and the property will remain residential and will remain within the R1 residential zoning district. The final criteria is I, which the granting of the variance may not substantially conflict with the comprehensive plan or the purposes of this ordinance. Applicant's proposed plan encroach approximately 15 feet into the rear setback that is adjacent to the OCRM critical line. And the applicant has stated in their materials that there's no substantial conflict as the end of the setback on the subject property will be that it will have a similar setback from the critical line to other properties in the vicinity. The critical line setback and buffer standards are intended to provide a protected buffer area between the furthest most projection of a structure, parking, or driveway area, or any other building elements, and all saltwater marshes, wetlands, and waterways, other than the ocean front on properties affected by the critical line. The purpose of the required buffer is to provide a visual, spatial, and ecological transition zone between development and the island's saltwater marshes, wetlands, waterways, and to protect the water quality and wildlife habitat. Here on this protection exists, due to the proposed construction of homes on the adjacent properties, and the construction will not alter the general setback from the critical line found in the vicinity. This project does not affect the comprehensive plan. Those are the outline approval criteria from staff. In considering this application, remind the Board of Zoning Appeals that you may approve with conditions or deny the case. If you are, in the event that the board does consider approval, staff has outlined one condition. Prior to zoning permits being issued, the applicant shall provide a landscape plan to the town's planning department depicting the native grasses and shrubs and/or plants to enhance the buffer between the OCRM critical line and the proposed structure. And then additionally, that you received in your materials, one letter during public comment period that was received from the town from a property owner at 220 Sea Marsh.
Questions for John?
Yes, sir. Hey, John, you said the critical line has moved. Do we know when it was first recorded, what it was, what it is today, and are there any projections X years out?
The reference plat, let's see, I'm trying to find the exact plat. The original plat from this particular lot, which is from I think from 1978. I don't know if you see that image. I don't have the exact distance of where that critical line is, but that would have been included all of the areas essentially drawn at. Let's see if I probably can highlight it a little bit from this. Essentially, that kind of would reference the original, similar to that line.
1978?
I believe so.
Which diagram are you talking about?
So if you look at the site plan, approved site plan,
It's,
He's using his pointer.
yeah,
the applicant has kind of labeled this DHEC critical line per reference, and so that would have been the previous record. There may have been one in between now and 1978, but that date, I am unsure of what that date may be, but this exhibit here would show you sort of a previous to what the current is based on this line
Oh, I
here.
see where the current is, yeah.
John?
Yeah, I'm sorry, the last part of my question was any projection going forward, 5 years out maybe?
I don't have that information today yet.
Thank you.
When the homeowners purchased this lot, did they do a survey to show where it was before they started with the building process, before they started with the architects to know where their lines were and what they needed to stay within?
Man, that's pretty standard practice, but I would allow the applicant to kind of answer that question.
Similar to the question about the OCRM line, there's really two things going on here. One, the OCRM line is moved, and two, the setback line has moved. And we adopted the current setbacks at some point in the past, and I gather the houses in the neighborhood were mostly built prior to that?
Yes, so you may recall from previous cases where there was a setback encroachment that created a non-conforming structure, and I think that's
Yeah.
maybe where you're kind of alluding to, where the setback may have encroached into an existing. That may be a similar case here based on adjacent lots. I can try to, so this would represent the property boundaries today. I don't want to share, because I have not done that, exactly where the setback line is relatively to the adjacent properties. That would be something I would more definitively bring that back to you if that's where you're requesting of where the adjacent property's setback line is. I just don't want to say I'm unsure.
Any other questions for John? Okay, Mr.
Just
Hirschon,
point
are you going
something
to
out
speak?
to just
I'm sorry.
about the OCRM setback line, because it's something that I've been dealing with, or the critical line, rather. When DHEC goes out and shoots those lines, they provide a survey, and it's stamped that this line is good for 5 years, right? So we know at the very least that, these lines can move every 5 years. There's in fact a dispute going on right now that's on appeal that I'm involved with about whether that 5 years is even protection, whether DEC can move that line, you know, in 3 years, for instance, if there's a big change. But generally speaking, those lines are only good for 5 years, and they come out and can reshoot it every 5 years, just so you understand. I mean, so they do move as a matter of law over time.
Does DHEC always come out every 5 years? Or is that
No.
something that the homeowner would
The
request?
homeowner has to
Okay, I just wanted
request
to
it.
make sure I clarified
But I
that.
think most homeowners and most builders feel like if they've got a line that's been set out within the last 5 years,
That they're good.
they're good. They might be wrong in that assumption, but we may find that out in a year or so, but,
That's consistent with how we would review permitted plans. If there's a survey provided within 5 years, then we would utilize that as our indication of whether or not it meets setbacks.
Thank you. Anything else before we call on the applicant? Okay, Mr. Hirschon, are you going to speak?
Yes, I'm speaking and then
Yeah. Please.
My name is Lawrence Hirschon. I'm an attorney in Charleston and represent the owner of this property. I want to say thank you to the board members for being here today. The summary provided by Mr. Taylor certainly touched on the 9 factors as we have set forth in terms of why a variance should be permitted here. And I think, you know, a lot of it basically goes back to, from a practical standpoint, just the concept of the neighboring properties here, basically the lines of houses that you do have, and where this house is going to fit in, by having this variance, will basically fit in line in terms of the depth of the house and where it is on the property, you know, in the property as positioned compared to neighboring properties. And that, in terms of what the purpose really is of this critical line, is about this, you know, how far the projection is of structures into and close to the marsh in this area, and here back to the Kiowa River. And regardless really of where this house is, it's going to be, the projections of the neighboring properties are already there. So from that standpoint, in terms of what the protection really is requiring, or what the idea is for the protection here, when there's only one empty lot with with neighboring being already being built, you're not having a situation where it's somehow, I guess, damaging what the purpose of that protection is. And I think still stays in line with what the board here is supposed to do in terms of looking out for whether it meets the comprehensive plan for the town, and whether this will be have any adverse condition or unreasonably cause any problems for neighboring properties. Now, I guess addressing the one neighbor who did submit something, and Mr. Sakis, the member of the owner, can touch on this as well, is there was a concern about whether it'll affect views of that property and unfairly somehow prejudice that property in some way because of that. And I think here Mr. Sakis will be able to talk to you that in terms of, you know, where that view is for that lot in terms of looking straight out, there's no effect whatsoever. It's really just if someone's going to turn their head, you know, absolutely sideways, and then yes, they're going to see that house, but that's going to be the same for basically any property when you have neighbors. I don't think I need to repeat everything that Mr. Taylor very nicely summarized, the positions that are set forth in the December 28th letter, and I don't think I need to belabor those points unless there's something that the board and the members of the board specifically would like me to address. But I think in general, you know, what is stated in this letter is that, you know, out of these 9 factors, the board can look at each of those as being met for allowing this change from 30 feet to 15 feet so that the structure can be built as shown in what's behind you at this time. And so unless there are questions to me, I think what I'd like to do is hand it over to Mr. Sakis as the member of the owner to kind of give you a little bit more detail on really the specifics of the structure, if that's acceptable.
I have a question. I still don't understand why you think you should have the same guidelines that existed 30 years ago with regard to property and how property was built in, and why you say we want it because they got it. I don't understand that.
I guess where I think of it and what I think of when I'm looking at zoning ordinances and where those affect in different towns and counties is the idea of having some of uniformity. So the idea is to have some uniformity of what is or what owners can expect. And here, what this is doing by there being something that was already done and constructed, we're trying to help with that. Or I think what this is requesting is, hey, let's still have that uniformity in that of what that historical position has been. And that's, I don't know if that's answering your question.
But your owner only purchased that a year ago. I mean, it's not like he knew what to expect when he purchased it a year ago. That's what existed. And it's not what existed 30 years ago. So that's why I don't understand his expectations seems to exceed what reality is.
I don't think it exceeds what reality is. I think, certainly, yes, an owner when they purchase land has an obligation to do their due diligence on what this is, and that's why he's here seeking this variance. I mean, I think he's aware of what it is, and that's why he's requesting the board to make a variance, to allow a variance for this purpose.
Yeah, but your variance is asking us to forget about the OCR and
It's not saying to forget about it. No, it's saying to.
Practically, you're completely ignoring it almost. So.
I'd respectfully disagree. It is acknowledging what it is. It is asking for it to be lessened. Still seeks, it's not asking for it to disappear. It's still saying that it exists. He has gone through the process of talking with the ARB to confirm what their requirements are, and of course, these are each different steps in the process, and this board has its own requirements and guidelines of what it needs to follow. But it's not asking for a complete disregard of those rules. It's asking to take a look at this property and to allow a variance for a structure similar to what's built on the street to exist.
I looked at the property. It's a small lot that you want a big house with a big pool with a big deck on it. And it's a small lot, and it was the same size a year ago when he bought it.
The lot is on the smaller size. It is staying within the 40% requirement. So it is yes, it's asking to use most of that 40%. Absolutely. I don't disagree with you on what it's trying to do with the lot.
Okay, so you're saying it's staying within the 40%. It's staying within the 40% when you ask for the variance for 786 square feet. So I walked that lot as well, and it is really, really close to the edge. And I'm not talking about existing homes. I'm talking about it is very close to the edge. You get a king's tide, and that water is going to be in his backyard. Was this his first rendition of the home? So they bought the lot, they had the survey done, they came in and they said, okay, this is what we want. Did you look at possibly shrinking any of this down without getting that close to the OCRM line or the critical line?
I don't want to misstate the history of the design, so I may need to let Mr. Sakis talk about that, but I believe there have been changes to it. I don't believe this is the original, but I don't want to make a misstatement there, so I think I'll need to let Mr. Sakis answer that question.
Any other questions?
And I know he'd like to speak, so if you'd like to please give him that same question, I know he'd be happy to answer it.
I just had one curiosity question. That little triangle-shaped piece that you appended to the lot next door, why?
Because of the requirements of to be permitted to be at 40% of the lot size, it requires the lot to be of a certain size, and so that did bring the lot within the size requirements or limitations to do 40% instead of 33%.
I see.
That was purposeful.
Does your client own that property next door?
No, that's a third party at, I'm forgetting if that's to the number of 20 or 24.
Thank you.
Yes. Okay.
Sure.
Hi, my name is Tom Sakis, and I'm the property owner of 222 Sea Marsh. I guess the first thing I want to address is I know we got a letter this morning. I got a letter this morning about the neighbor to the left in terms of the view, I think it was. And I actually, if you look at, I guess it's this slide.
the letter within our packet?
Should be the same from 220 CMOS.
Yeah, that one, yeah. So if you look at that, okay. My property would be set back behind both those houses, so it would not obstruct.
You're on the left?
No, I'm in the middle. I'm the
Property owner.
I'm the property owner, right. As you can see, my lot is actually further back than both of those houses. So his view would not be really impacted unless he was to turn completely to the right.
Anything else, sir?
And then in terms of, the critical line, the issue is that, the reason I'm asking for this is because the lot is very small, and it makes it very difficult to get any decent sized house on there that actually would conform really to the neighborhood. If you look at the distance from the front door to the back of the family room, it's only approximately 25 feet, 26 feet. So if this variance isn't granted, then that reduces that by another 15 feet.
What's changed since you bought it? Nothing. That's the way it existed when you bought it, right? It was the same size when you bought it. Okay.
Anything else? Okay, other speakers? Sir? You?
Hello, I'm Tom Emanuel, Director for the ARB. Thanks, John, for including the letter from the ARB in support of the variance. The ARB did review this in context and considering the significant encroachment that the critical line had on the property, it felt like that was a hardship in terms of developing this in a way that would be in context with the neighborhood and with the neighboring properties. That being said, the ARB will, did look at this also in the context of how the shape of the lot is configured, meaning that it's sort of indented like this, right? So that does not really impact the neighbor's views, as Mr. Sakis was saying. So that was something that the ARB had considered as well. Be happy to answer any questions that the board members may have for us on this and how we approach this, but it was mainly given the significant encroachment of the critical line movement on the lot.
But I just want to go back to when they bought the lot, it hadn't moved since that point. So you added that triangle for the coverage. Am I correct in understanding that?
That was added, correct. Yeah.
Okay.
Well, the ARB did not. The ARB approved that. That was an application by the applicant.
So they don't own that piece of property, but they're counting that piece of property in the square footage so they can get the home the size they want.
I don't think I understand that. No, that's not correct. They did.
No, he didn't. He said that he did not own that lot, that triangle. You asked that question.
Okay, maybe I missed.
Did I misunderstand it myself?
I just want to clarify for the record that if you see in your materials, I don't know if I have that. This area, the triangle that's referenced, if you flip in your materials, you'll see the subdivision plat that was recorded. That area, that triangle area was removed from the subject property to the adjacent property. So the homeowner does not own that triangle. I just wanted to clarify that triangular shaped piece there. The homeowner does not own that. That's in part of the adjacent property.
The homeowner transferred
Transferred that.
to the adjacent property.
Okay, I
I guess I
misunderstood
don't
that.
get then why, I thought Mr. Hershon said he did that for reasons of percentage of coverage.
That's what I heard.
That's what I heard. That's why I asked
And
my
it
question.
seems to be going in the wrong direction for that.
I would let the applicant
Yeah.
answer.
I'm sorry if I created confusion with that comment, certainly not my intent. If you're, and I'm forgetting the numbers, but if your lot's a certain size, you're allowed to have coverage for the house that's at 33%. That's
Oh,
where
I
it was with this triangle included. When he transferred that triangle out to transferred it to the adjacent owner, that he's not, that's a third-party, arm's length transaction, it brought the square footage of this lot to a size that allowed for 40%.
I understand.
And the ARB, and that went through a process from approval. He couldn't just do that voluntarily. It was a process that was approved through the town.
It lowers the denominator, how does that?
But it doesn't change the 768 square feet you're asking for.
It doesn't change that, no. As I think as to your question, the lot is the same, I guess in terms of where the critical line change has happened over time. It's not something that's occurred, my understanding is it's not something that has occurred between the time of acquisition and now, but it is something that as it has moved further into the lot and has created this honestly a difficulty in how to best build a home that fits within what the Kiowa community likes to have.
Okay. Other questions?
Part of the conditions for the variance too, for the ARB, was that they would only be allowed that pool deck in that zone, as well as only one story. So the ARB was sensitive in terms of, the encroachment on there, how much
There is
massing
heated
was.
space though in that, there is heated space as well.
Correct, but it was limited to one story.
Okay, anything else? Okay, I'd entertain any motions that anyone would care to make.
I just had a question, Frank. The person that wrote the letter, they're not here present today for questions. It's just we have the one
Yes.
opposing letter and no one else speaking in favor.
Is that correct, John? That's the only thing we've received.
Okay, I'm sorry, Frank.
Anything else? I'll entertain any motions.
Okay, I'll make a motion. I recommend that we deny this request for a variance based upon the fact that I think the criteria A, B, C, and G are not met, and among others. And also the fact that the property as it exists now was fully, all the restrictions were fully in place when the owner bought it, with full knowledge of what he was buying. So I recommend that we deny this request.
Is there a second?
Second.
Any other discussion? Okay, I'll take the vote. Morris? How do you vote?
Deny.
So you vote yes on the motion.
Yes on the motion.
Ben?
Yes.
Lynn?
I vote yes on the motion to deny the variance.
Jay?
Yes.
And Frank also votes yes, so it's unanimous in denying this motion, I think on the basis of,
Denying the application.
I'm sorry,
Denying the
denying
application.
the request for a variance on the basis of violations of criteria A, B, C, and G. And I'll just add that I think this is the largest, in terms of square footage, variance we've ever, at least I've ever considered. So I think it's a little beyond what we would typically do. Okay, that concludes that. John, is there any other business? All right, we're adjourned. Thank you, everyone.
Thank you.
Thanks, Frank.
John, we do have a March
Not to mention this nonsense.